Welcome to Ask John. Today, John, our discussion is centered on Unit 5, Question 1. A lot of questions about the historical background of the Bill of Rights. We have a lot of questions from Arcadia High School in California. Let's start with Benjamin's question. He wanted to know, what were the events that necessitated or went into the creation of the English Bill of Rights?
Well, the English Bill of Rights is a specific document, 1688, 1689. It at first was a Declaration of Rights, and then it went through the formal process of becoming an act, and it was then named the Bill of Rights. But it was the culmination of a number of events. Very similar events had occurred throughout English history when the monarch, whether generally it was the king, who violated the rights of Englishmen, whether those rights had been embodied in the common law or in some of the great documents. But whenever that occurred, the Englishmen would respond to the king's tyrannical actions and present a document. Magna Carta was one of those documents. Petition of Right was one of those documents. And then in 1688, the Declaration of Rights was one of those documents. So this was in the English Bill of Rights was a document in which Parliament said that the king was doing these inappropriate actions. And that's one of the differences between the English great documents and the protections of rights versus the American documents. And there's over 200 of these American documents that protect rights during the colonial times. In colonial America, these were peremptory statements. These were statements to the government: don't do these things. And if you do them, we're not going to support you. We will oppose you. In England, it worked the other way. It was when the monarch violated the rights, then the opposition, whether it be the barons against King John proposing the Magna Carta in 1215, or whether it's the House of Commons opposing Charles I with the Petition of Right in 1628, or whether it's the Parliament opposing James II in 1688 with the Declaration of Rights that becomes the Bill of Rights. And so the Bill of Rights is a listing of all the things that the king had done that violated the rights of Englishmen. And so that's, and James II did a lot of things that Commons did not like. And it was these things that served as the foundation to depose the king. And when William and Mary were invited to take the throne, they had to agree to abide by the Bill of Rights, that they could not, in essence, do the same things, tyrannical things, that James II had done. And both William and Mary agreed to abide by those rules.
So, what was the basic difference between the English Bill of Rights and these American colonial bills of rights?
Well, the main difference is the fact that one, as I mentioned, referred to acts that were already done. The British, English, and then British opposition to the crown. And in America, because there was no cadre of lawyers that were trained to go into the common law, the Americans felt that they needed these rights to be protected in a peremptory fashion. Americans had gotten their religion, that's put in quotation marks, from the essayists, the writers in the 17th century English debate. There were 22,000 pamphlets that were printed in England in the 17th century, arguing about how to have a viable government and to protect rights. Some went to the extreme of the divine right of kings. Others were actually advocating communistic systems. They called it levelers at that time. So the whole range of those kinds of arguments. Well, the Americans were reading all of that and understood a great deal of it and came to have a natural suspicion of government. They bought into the Whig philosophy of government, that government is always endangered because of the depravity of human nature and the propensity of people who have power to seize even more power. And so the Americans wanted to list their rights in advance to assure that their leaders understood how they ought to be governing. Now, for the most part, they addressed the same rights. There was never a totality of rights. In fact, the English Petition of Rights, for instance, in 1628, is a very short document because the arguments against King Charles I were very limited. And that's true also in the American colonies. That's why you have 200 and some documents that list the rights. There's none that list all of the rights. Although the Massachusetts Body of Liberty, done in 1641, gets very close. It has all the rights that are in the English Bill of Rights of 1688, all the rights that are in the American Bill of Rights of 1789, 1791, and even more rights. It had rights for women, it had rights for children, it had rights for servants and rights for slaves, it had rights for aliens, and it had rights even for animals. You could not work your horse too hard, or you could not drive your cattle too long. There'd be penalties for that. And so the Massachusetts Body of Liberty was really pointed to as one of the great documents in colonial America. I should mention, though, in the last page of the Massachusetts Body of Liberty, which historians often don't refer to this last page, there was a list of about a dozen or so capital offenses. And so if you went the wrong way, if you were guilty of blasphemy, if you were guilty of abortion, if you were guilty of bestiality and guilty of homosexuality, a whole list of a dozen or so, these were capital offenses. And if you were caught in the act, you would be punished appropriately. Now, a lot of these things were being done in colonial America, and it's not as if these activities didn't take place. But as I said, if you're caught in doing these things that are listed in the Massachusetts Body of Liberty, you could be executed. And justice was pretty immediate back in those days. It was not a question of any appeal process. If you were found guilty, that punishment was usually quite severe and quick. There's not long-term imprisonment at that time. You had execution for many, many different things. And then you had some kind of corporal punishment, that is branding or chopping off an ear or slitting a nose or whipping or putting in stocks. So these were the punishments that were inflicted very, very quickly. So although rights were protected, there were a host of things that you could be punished for, and punished quite severely.
So let's fast forward a little bit to the states' bills of rights. And Sarah wants to know from Arcadia, how much influence did these states' bills of rights have on the creation of the U.S. Constitution Bill of Rights?
Oh, a great deal of influence, no doubt. And in fact, in the Constitutional Convention, when the proposal was put forth, let's have a Bill of Rights. George Mason, one of the advocates for a U.S. Bill of Rights, he had been the author of the Virginia Declaration of Rights back in 1776. That was adopted 2 weeks before the Virginia Convention was adopted. But Mason advocated a Bill of Rights, and he said, I could propose one in 2 or 3 hours. All I need is the Book of Constitutions, which was a little tiny book that listed all the state constitutions and the Bills of Rights. And he said he could glean a U.S. Bill of Rights from the Bill of Rights of the various states that were listed. Ironically, the Virginia Bill of Rights, Declaration of Rights, I should say, was not listed in that book. And it was because the Virginia Declaration of Rights was not technically part of the Virginia Constitution. It had been adopted 2 weeks before the Virginia Constitution, so it was even more fundamental than the Virginia Constitution. So many of the rights that are in the U.S. Bill of Rights can be found in the state Bills of Rights, but there are many, many others that are in the state Bills of Rights that are not included in the U.S. Bill of Rights. And partly that was not Madison's fault, and partly it was Madison's fault. Madison, as the primary spokesperson for advocating a Bill of Rights in Congress in 1789. Madison wanted to have a preamble to the American Bill of Rights. And in most state Bills of Rights, there are preambles. And the preamble states that all men are created equal. Now, that might be thought to be merely symbolic. It wasn't. Look at what that statement in the Massachusetts Declaration of Rights did. John Adams was the author, primary author of the Massachusetts Constitution and Declaration of Rights. And in particular, starting out the Massachusetts Declaration of Rights saying all men are created equal. Chief Justice William Cushing of the Massachusetts Supreme Court used that phrase to emancipate all the slaves in Massachusetts. Slavery, he said, was never legitimate in Massachusetts because the Massachusetts Declaration of Rights was based on the presumption that all men are created equal. And so the preamble is an important factor. All power is given to the people, preambles would have. The consent of the people was necessary for government to exercise its functions. These are parts of the preamble. There are other general statements that appear in the body of the state Bills of Rights that don't appear in the U.S. Bill of Rights. Statements like separation of powers should be advocated. The military should always be subordinate to the civilian government. So things of this nature. But for the most part, the state Bills of Rights and the federal Bill of Rights were aimed at the same thing, limiting the power of the central government. They were not advocating what we might call today positive rights. That is the right to an education, although education would be advocated in the state Bills of Rights. It would not advocate a job, would not advocate health insurance, things of this nature. But more often than not, the U.S. Bill of Rights and the state Bills of Rights were negatives on the government. The government should not do this. The government should not do that. And in fact, there is a difference. You notice I use the word should. The word should is often used in state Bills of Rights. And it's stating a preference. This is what it should be like. And it is not necessarily enforceable in court. Whereas the U.S. Bill of Rights is based on the foundation shall or shall not, which is a actual statement that Congress is not authorized to do these actions. Consequently, can be operated on in a legal situation. So that's another major distinction that's there in the state Bills of Rights versus the U.S. Bill of Rights. But I would say almost all of the rights that are listed in the U.S. Bill of Rights are listed over and over again in the state Bills of Rights, and there will be some extra ones as well, looking back to their English precedent that they would remember. So, for instance, in the Virginia Declaration of Rights and in the New Hampshire Declaration of Rights, there was a provision criticizing the doctrine of non-resistance to arbitrary power as being slavish, absurd, and opposed to the happiness of mankind. And therefore, this doctrine of non-resistance, which comes over from England, that you must abide by whatever the government says, and this is part and parcel of the divine right of kings. God has a relationship with the kings, and therefore anything the king does wrong, the king will pay for in heaven. But here on earth, we must obey what the king says. That's not what's in the American state bills of rights. That doctrine is repudiated. And so these state bills of rights are pretty thorough, I would say.
You've touched on this briefly, but Joanna from Arcadia wants to know, why did they not create a Bill of Rights at Philadelphia? That seems to be a major omission on their part.
Certainly that's the case, and people will argue that, most historians in fact will present the case, that it was a good thing that Adams was in England and Jefferson was in France during the Constitutional Convention, that these two men would not have functioned well in the Constitutional Convention. I don't agree with that. And one reason I don't agree with it is because I think if Jefferson were there in Philadelphia, he would never have allowed the convention to adjourn without a Bill of Rights. And so he was a staunch advocate for a Bill of Rights. So it's a good question. Why was there no Bill of Rights? Since Americans were very concerned about their rights from the very beginning of the settlement, and certainly many would argue that the American Revolution was fought to protect rights against the British, who were violating the rights of Englishmen and the constitutional rights of Americans. And so if we look at the Constitutional Convention, I think what we find is that the Constitutional Convention was called to amend the Articles of Confederation, and it was hoped that it would do 5 things. One, it would preserve the Union. That was the most important thing. The Union was in jeopardy, and they understood the danger of disunion. Second, take away some powers from the states. The states had too many powers. Third, give Congress some more powers. Congress needed some more powers. Also, to give Congress some economic clout that could be used to help fight economic depressions. So a national currency, let's say, that would encourage economic activity. And then finally, to restore the image of America in the eyes of Europe. America had a very illustrious reputation during the Revolution for the colonies to stand up against this powerful Great Britain. The mother country was really quite remarkable. But given the problems that occurred during and after the Revolution, the image of America was tarnished. And so the hope was, let's try to restore that. It's an important factor in foreign relations. So when the Constitutional Convention came together, they didn't come together to protect rights. In fact, there was the assumption that one of the problems was that there were too many rights. One of my favorite articles appeared in the newspapers in the Albany Gazette of the 21st of June, 1788, in which it says we've got to look at who we are, human beings, and who we are as depraved human beings. We need to give power to the government, this article says. And then it says something that I don't think could have been said in 1774 or 1776. This article says, we are wallowing in the superfluity of liberty. We have too much liberty. And in fact, the danger in government can often come when too much liberty ends up in anarchy and licentiousness. And when that happens, people eventually get tired of that, and the tyrant comes along, the dictator, who will promise peace and stability and benevolence. And that will happen in a short period of time. But benevolence will then disappear pretty quickly, and you'll get tyranny. And so too much liberty is a very, very dangerous thing. And so they weren't, the Constitutional Convention wasn't about to take away liberty, but it wasn't about to extend liberty too broadly. And so when they reached the end of the session. Often the historians will say they were tired, they wanted to go home, and that's why there was no Bill of Rights. Well, and it was a hot summer. Well, it was a cooler than normal summer generally in Philadelphia. There were some hot days, to be sure. But I think what happened was toward the end of the convention, let me preface that by saying, throughout the convention, when individual rights came up, they were often incorporated into the Constitution. And so the protection for jury trial in criminal cases, and no ex post facto law, no bill of attainder, et cetera, these things are embodied in the Constitution, often in Article 1, Section 9 and Section 10, both protecting against federal action and state action. But toward the end of the convention, when the proposal was made, let's have more rights protected and let's have a Bill of Rights, that's what bothered some folks. They felt that they were creating a government of delegated powers. And that's all that was in the Constitution, was delegated powers. And more specifically, there was the fear, if you start debating the rights, most Americans thought they knew what the rights were. You talk about freedom of the press, they knew what that was. They knew what freedom of religion was. Now, they didn't always agree, but they felt that they knew. Now, when these issues would be brought up in the context of this new draft Constitution in the Constitutional Convention, it would have opened up a Pandora's box. It would have opened up the debate over everything that they had already settled. How does freedom of the press fit in? How does freedom of speech fit in? How does cruel and unusual punishments fit in? And so there was a fear that all of their work done in 4 months period of time could be unraveled. Now, it's also insightful to see when the delegates go back home in South Carolina, the delegates were to report to the State Assembly as to what happened. And Charles Cotesworth Pinckney did report to the South Carolina Assembly in January of 1788. And the Assembly said, how come there's no Bill of Rights? And Pinckney's response was, well, Bills of Rights are usually premised on the basis that all men are free. Do you want that in a federal Bill of Rights? He said, look around. 50% of South Carolinians were black slaves. They didn't want constitutional equality of blacks and whites. And so they said, good, it's a good thing there's no Bill of Rights in the Constitution, no federal Bill of Rights. So there were a number of reasons, but I would say primarily those folks who were in the Constitutional Convention believed they were only creating a government of delegated powers.
This would be a good spot to transition to the first Congress and James Madison. Emily from Arcadia wants to know the process. So maybe you could address James Madison's process and then maybe Congress, the process that they used to create the Bill of Rights.
From the get-go in the ratification debate, there is a discussion of the lack of a Bill of Rights. I would say there are two broad issues that are debated, and virtually every provision of the Constitution is debated. But the two broad issues are, one, the new federal-state relationship that's going to be established, and the second, the lack of a Bill of Rights. And so those are issues that come up all the time from the very beginning. And in fact, in the Confederation Congress, there is a debate over the issue of sending the Constitution to the states. And right away, the Anti-Federalists there, the opponents of the Constitution, led by Richard Henry Lee, says there should be amendments and there should be a Bill of Rights. And he proposes a Bill of Rights. Madison argues against it. He says, well, we can't do that. The report from the convention is like a committee of Congress making a report. And that committee is gone, not to come back, and we can't change that report. A number of people said, that's ridiculous, Mr. Madison. We have committees all the time, and we change the reports. So how do you say we can't change a report of this committee, the Constitutional Convention? Madison agreed he was wrong in that statement. But he said, if we propose amendments to the Constitution as sent out by the Constitutional Convention, we'll have two constitutions, one with amendments, one without. And what happens if 5 states adopt one and 5 states adopt the other? We'll be in a real bind. And so he said, let's adopt the Constitution first, and then we'll get the amendments second. It's easier to get amendments under the Constitution than to get amendments under the Articles of Confederation, because the Articles of Confederation required the unanimous approval of all state legislatures and the approval of Congress as well. Under the Constitution, there were a couple ways to propose amendments, including proposal by 2/3 of both houses of Congress, and then the ratification of only 3/4 of the states acting either in their legislative bodies or in state ratifying conventions. And so why not wait? And let's look at the experience that we might get, that maybe amendments are needed. So that's an argument that is brought up regularly and is opposed all the time as well. The Massachusetts Ratifying Convention comes up with a new method of ratifying. They ratify unconditionally with recommendatory amendments. And there are 9 recommended amendments. They're not divided into categories, as they eventually are by Virginia, North Carolina, New York, and Rhode Island. And in those states, their ratifying conventions propose, in the case of Virginia, 20 Bill of Rights type amendments and 20 structural amendments. Pretty much North Carolina and Rhode Island and New York follow the example of Virginia. They add maybe a couple extra amendments here or there. But these are to be considered by the first federal Congress. The senators and representatives from those individual states, Virginia, New York, Rhode Island, North Carolina, are to propose these amendments in Congress. And Congress is then to consider whether to send these amendments out. So you've got structural amendments, let's say no vice president. That is a structural change. There'd be a privy council, that the Senate doesn't have the power to ratify treaties and to try impeachments and to approve appointments. A special privy council would do that. So these are structural changes. And then there are the typical kinds of rights amendments that were proposed. And so that was what was expected, that the first Congress would follow these recommendations of the states. In fact, 6 of the 7 states that ratified after Massachusetts followed that technique of recommending amendments. But that technique of recommending amendments through the first Congress was really denigrated during the first federal elections. And you can see the opposition, the Federalists are running, calling those folks who want amendments to be amendment mongers, amendment-ites. They're trying to kill the Constitution. And so there is a movement afoot not to consider amendments in the first federal Congress. And so Madison is put in an awkward situation. He was defeated for election to the U.S. Senate in the Virginia legislature, largely through the power of Patrick Henry, who hated Madison and Jefferson and wanted to keep him out of the Senate. It was reported, a friend of Madison reported to him, Mr. Henry said, if you are elected to the Senate, rivulets of blood would flow throughout the land. And so he was defeated. 2 Anti-Federalists were elected to the U.S. Senate from Virginia. And then Henry tried to gerrymander Madison's district when Madison was going to run for the House of Representatives. There would be 10 representatives from Virginia. Patrick Henry, who controlled the Virginia legislature, tried to put as many anti-federal counties in Madison's district as possible. And these counties were heavily Baptist. And so Madison understood that the only way that he could get elected, running against his good friend, But Anti-Federalist James Monroe was to promise that he would support amendments to the Constitution, particularly a Bill of Rights, particularly in the Bill of Rights, freedom of religion. And so he wrote several letters, which he, to friends, saying, publish these letters, saying that I've always supported a Bill of Rights, when he really didn't in the Constitutional Convention and in the ratification debate. He didn't support the Bill of Rights. But now he's saying there's nothing that I find objectionable to a Bill of Rights. I would support a Bill of Rights if I'm elected to Congress. And he was elected, and he did go to Congress, and he announced pretty early that he was going to propose a Bill of Rights. In fact, I should say, he drafted Washington's inaugural address, and both Washington and Madison wanted a Bill of Rights. It's the only thing that's in Washington's inaugural address, the only grocery list, let's say, of what he wanted from Congress, which was a Bill of Rights. So Madison agreed with that in drafting that inaugural address. And Madison gives a speech in which he says, in May of 1789, I will support a Bill of Rights, and I'm going to give a speech pretty soon. He gives that speech in June of 1789. It's a wonderful speech in which he advocates a Bill of Rights. He doesn't advocate structural amendments to the Constitution, but a Bill of Rights. Many people in Congress oppose him. Federalists propose him because they think it's premature, and there are other things to do, setting up the government, setting up the tax system. Every day that there's no tariff, that revenue is going to Pennsylvania, New York, and Virginia, but not into federal coffers. We need to get the federal system set up, and we need to set up the government. We need to set up the judiciary, and Madison wants to get us involved in a discussion of the Bill of Rights, which could take months. And so there was a lot of opposition. The few anti-federalists that were in the Congress, they also objected to Madison because they felt all he was concerned about was rights type amendments, not the structural changes, which they felt were very important as well. Well, Madison was true to his word, and he proposed these amendments on the 8th of June. It's a fantastic speech. He really understood the issues. Why not? He's a great thinker, and he had opposed the Bill of Rights for a long time. Who better to advocate a Bill of Rights than a former opponent of the Bill of Rights? And so he put this forth in the House of Representatives and failed. He understood he needed to get the 2/3 majority necessary to kick those amendments over to the U.S. Senate. He failed. So he asked Washington for some help, and Washington published a statement, I favor Mr. Madison's amendments. And with that support of Washington, President Washington, the House of Representatives passed by a 2/3 majority those amendments. They went over to the Senate. The Senate considered them and revised a few, kicked out a few, kicked out the most important amendment as far as Madison was concerned. That is, the states should be prohibited. And remember, the states, not the Congress, but the states should be prohibited from violating freedom of speech, freedom of conscience, the freedom of the press, and the right to trial by jury in criminal cases. Now, we don't have the journal of the Senate. They met in secret. But the presumption is the Senate didn't want its constituency, that is the state legislatures, to be limited. And so that amendment was deleted from the amendments that had come over from the House of Representatives. Eventually, the two houses agree on 12 amendments that are to be sent out, and those amendments are sent out by Congress through the auspices of George Washington. He sends a cover letter with the amendments, 12 amendments, sent out on the 2nd of October, 1789, and the states start to consider those amendments. Each state considers them in their state legislature. They're ratified eventually by 3/4 of the states. It takes 11 states once Vermont comes into the Union. Only one state defeated the amendments. That was Georgia. Georgia thought that the amendments were premature. Massachusetts legislature and the Connecticut legislature, bicameral that they are, One house passes 10 amendments, the other house passes 11. They never reconciled their different actions, and so those two states did not ratify the Bill of Rights in 1789. But when Virginia becomes the 11th state to ratify, December 15, 1791, I should say, the 10 amendments are adopted. The three non-adopting states, Georgia, Massachusetts, and Connecticut, symbolically adopt the Bill of Rights in 1939, the sesquicentennial of the proposing of the Bill of Rights, and obviously a time in world history where, as President Washington said, the fascist tigers in the world were threatening liberty. And so there was an argument in favor of a Bill of Rights at that time.
Some people have wondered, is there a specific reason that rights are listed in a particular order? And that Jennifer, from Arcadia, wants to know that. Is there a historical reason for the order of the rights in the Bill of Rights?
Yes, there is, and all too often, however, it's mistaken. People will say the rights in Article 1, the First Amendment, are the most important. That's why they're in the First Amendment. And so as you go further down the line, they become less important. That's just entirely incorrect. That's not why the amendments are listed the way they are. They're listed that way because James Madison, who proposed the amendments, proposed them in the order that they would come up in the Constitution itself. So what Madison wanted to do was to have a preamble that would be added to the preamble of the Constitution. And then the various amendments would be inserted in the Constitution wherever they were appropriate. And so the First Amendment protections happened to fall in Article 1 of the Constitution up front, and so that's why they fell at that point, because Madison would have put them in the body of the Constitution up front. And so that's the order of the amendments, is how they would have been situated in the Constitution the way it was adopted. That Madison idea was in effect until the 19th of August of 1789. The debate in Congress starts really in June of 89 and goes till the end of September. So you see, for almost all of the debate, up until the last month of the debate, the amendments to be added to the Constitution were going to be put into the body of the Constitution. Ironically, the main person opposing that was Roger Sherman, who had opposed the amendments in the Constitutional Convention. He's the only one who opposed the amendments in the Constitutional Convention. He opposed amendments in the ratification debate in a couple of serial newspaper articles under different pseudonyms, and he opposed the Bill of Rights in the Connecticut Convention. He opposed the Bill of Rights in the Congress, but once it was decided there would be a Bill of Rights, Roger Sherman argued, let's keep them separate. Let's put them in the back in the form of a Bill of Rights rather than intruding. We shouldn't mix the gold of the Constitution with a lesser alloy. They should be kept separate. And many people would argue that by doing that, the actual amendments have greater strength because people look at the Bill of Rights as a separate entity. In fact, when people talk about the Constitution today, they often talk about the Bill of Rights as opposed to the structural part of the Constitution that makes up the form of government. And so it was Roger Sherman primarily who opposed Madison in the organization of where the Bill of Rights would fall. And that original idea of Madison is what gave us the ordering of the amendments.
Selena from Arcadia wants to know, should we actually consider the Bill of Rights to be a progressive document or not?
Well, I certainly think that the Americans at the time believed it was a progressive document and that it would limit the authority of government and protect the rights of individuals. I mean, what we have seen over the 230 years or so, we understand that it doesn't go as far as many liberals and progressives would like to go in guaranteeing certain basic human rights. That is, the right to an education, the right to housing, the right to
Healthcare.
health. Yes, these things are not embodied in the Bill of Rights. So from that perspective, it's not a very progressive document. We've had to glean certain rights from the amendments and some privacy rights, let's say. And instead of going to the Ninth Amendment, which says that there are many other rights over and above the rights that are listed in the Constitution and the rights that are listed in the amendments, but all too often we don't go to the Ninth Amendment because of the fear that judges have that there would be too many rights that would be looked to if that amendment was extensively used. So we look to the other rights, and as Justice Douglas would say, the penumbras of the Fourth Amendment and other amendments, and we look to the provisions of the 14th Amendment affording equal protection under the law. So a lot of our progressive interpretations of the Constitution come from those provisions rather than from the direct provisions of the Bill of Rights itself.
Karen from Arcadia wanted to know, why does the Bill of Rights specifically restrict Congress and not the other branches?
It was thought at that time that Congress was the primary branch of government, particularly a Republican form of government. And so if you look at the Article 1 of the Constitution, the fact that it comes first and the fact that it is multiple times as long as the other branches of the government, it was felt that in republics, legislatures are dominant. And in fact, James Madison, in his various writings, alluded to that, saying that Republican legislatures, that is, legislatures in Republican forms of government, try to absorb everything in its powerful vortex, and that's where rights can be violated. And so government, Congress's legislatures had to be limited, and so the Bill of Rights was primarily aimed at Congress. But there are other branches of the government that are covered as well. I mean, obviously, we see habeas corpus is applied to not just the Congress, it's not in the Bill of Rights, but in the body of the Constitution, where Congress is prohibited from violating the writ of habeas corpus, except in cases of rebellion and armed invasion. But when President Lincoln used that power, eventually suspended that power, it was argued that he didn't have the power to do that by the Supreme Court. So by interpretation, some of the other branches are limited. It's pretty hard to limit the judiciary, given the fact that the judiciary in our system interprets what the Constitution means. And so given the precedent that we have with the judiciary, the argument in favor of judicial review, which is, I think, a pretty standard argument that has come about through one precedent after another. I don't think that there's too many actual limitations on the judiciary per se.
Our last question comes from Suez, again from Arcadia. In your view, what's the most important right in the Bill of Rights?
Well, I could argue the First Amendment is the most important because it's first, but I just said that's not the reason why it's first. But certainly the people have argued that the First Amendment is most important because the freedom of the press and freedom of speech is so important that as long as you have a free press open and freedom of speech, you can protect against other detriments. Other people would argue that the most important right in the Constitution is the right of habeas corpus, which is not in the Bill of Rights. It's in the body of the Constitution. Again, if you have your day in court, if you're brought out of prison and you can speak out and you have the other rights, you have the rights that are primarily in the Fifth Amendment, these common law rights, a speedy trial, right to witnesses, to address witnesses, a right to be told what you're being tried for, things of that nature, a right to counsel. These are very important rights and would go hand in glove with the habeas corpus protection in the body of the Constitution. So I would say those two rights, the Fifth Amendment protections of common law judicial rights, and the First Amendment rights of freedom of speech and freedom of the press, seem to me pretty powerful, and all other rights might be subservient to those two rights.
Well, thank you, John, for joining us, and we have enjoyed this series. And on behalf of the Center for the Study of the American Constitution and the Center for Civic Education, thank you for joining us.